I'm really excited to be here today with all of you to fill you in on some of the new, exciting, innovative changes happening at CPR's Dispute Resolution Services. I actually don't have to stand behind the podium, So while the CPR Institute, our think tank, continues to bring together members to share best practices, develop tools for dispute management through committee discussions and projects and publications and events like this one, our dispute resolution services side is uniquely positioned to help manage and resolve these disputes by leveraging those resources that arise, that come out of the Institute, generated by ADR leaders such as yourselves. CPR Dispute Resolution, or DRS, is a preeminent provider for business disputes, providing boutique-style and leading-edge dispute management services. So we're here for you, attentive and engaged. I know the big question on everyone's minds, and I got that question in the HOVA app, is what's coming next? We are getting ready to launch our new complete case platform, a state-of-the-art digital platform for case management powered by mediation. I would like to say with moderate certainty that you'll be able to be using it this time next week. Very exciting. For anyone who has launched any kind of product, I'm sure you know that these technologies can really take some time to get out there, so we've been looking forward to this. The platform's going to bring parties, neutrals, counsel, access to a digital legal environment that's going to allow everybody to handle matters more efficiently. It's going to be a filing platform, provide for secure communications, selection of neutrals, and case management by administrators, by the neutrals, in a more streamlined and expedited fashion. The platform's video conferencing capability is integrated into the platform. And it's designed with features that are really purpose-built for arbitrations and mediations. And it's one of the very few online options for dispute resolution that is ISO 27001 certified, which is a leading international standard for information security. I know we've talked about security this week, so we take that very seriously. There are also some really exciting new staffing changes at DRS. As you've heard, Helena Erickson is going to be moving over to our Institute side. And so I'm thrilled to announce that we'll be adding another staff person as of Monday, Natasha Richardson. Natasha, along with Nancy Vastardis, will be managing our DRS caseload. Those of you who file cases with us and neutrals, you should be expecting to see their names and their faces on communications and meetings going forward. One of the many benefits of having CPR managing your matters is the DRS team. We're responsive, efficient, and detail-oriented, and you'll be able to see that in all of the communications and matters going forward. Our team has extensive experience in ADR with backgrounds at a variety of provider institutions, and we've managed matters across the globe in different subject areas. And I say this because I want you to consider me, and I want you to consider our DRS team a resource that you can reach out to with questions. Not only if you have a case that is going forward with CPR, but any questions about the rules or the process, we're here for you. So while I know a lot of you here are familiar with CPR as a think tank, I do want to take a moment to emphasize that our DRS arm is equally impressive. We're a full-service dispute management service provider. So all of the innovative approaches to ADR that we've been hearing about the last few days are included in our suite of services, and so you can see those at DRS. Starting with the dispute prevention stage, we maintain a roster of dispute prevention neutrals, skilled in facilitating conflict management and solving business tensions before they become legal conflicts or claims. We can also assist parties in appointing deal facilitators or dispute resolution boards. Then for those of you who were moved by yesterday's panel on mock arbitration, we have been offering assistance with impaneling tribunals of mock arbitrators with qualifications similar to those of your actual tribunal if needed. We can also help with setting up early neutral evaluations or mini trials. Then, as you might recall from the last session yesterday, we launched a new service as a pilot program called B2B Dispute Resolution Planning, which is essentially a mixed mode project. In that, parties work with a neutral, the process design facilitator, to create an ADR process that's uniquely suited to the parties' needs, their interests, and the nature of the dispute at hand. During the pilot phase, we're actually running it so that parties can sign up for 4 hours for free of charge, so that they can work with the process design facilitator to consider all of the options throughout the ADR process. And this project really arises out of the idea that parties may not have fully considered their options on how to best resolve the dispute. Or maybe they're relying on a dispute resolution clause that was drafted years ago before they had any idea of what kind of dispute would arise. I think this process will help parties achieve a more efficient and effective ADR process and ADR procedure, and one that's tailored specifically to the dispute at hand and not off the rack. And finally, we do, of course, provide full administration services for mediation and arbitration, as well as a la carte services such as neutral appointments, challenge reviews, or fund holding. So one of the great things about CPR as a whole is that our rules, protocols, and model clauses are driven and informed by the CPR Institute and developed by users who are on the front lines of dispute resolution. So in an effort to further understand how this benefit was helping our rules, we created a comparison chart this fall that looks at the domestic commercial rules of CPR, of the AAA, and of JAMS. You can actually download that on our website or just email me. I'm happy to get that out to you. But the guide, in reviewing the differences and similarities of the various institutional rules, really emphasizes the benefits of using rules that have been created by those people who are using them. And just quickly, some of the striking differences include CPR's approaches to confidentiality, our screen selection process, which was mentioned yesterday for appointing party-selected neutrals, our approaches to early disposition, cybersecurity, and even our young lawyers rule. And through the comparison, we were able to see that our administrative costs were indeed lower than those of our competitors. So I hope that you all take a second or a few minutes as needed, to review the chart and consider learning more about and using the rules that you all helped create when drafting your next ADR clause. We also have a wealth of resources hosted on our site and in our virtual library, from model clauses to training videos to protocols and guidelines. And we've had a few updates to those over the last few years. Our protocol on the disclosure of documents and presentation of witnesses in commercial arbitration. It provides for multiple modes of discovery and witness presentation that can be decided at the outset and written into your contract, or discussed with the neutrals on your preliminary conference. And I think that's really helpful in creating a process that can be more efficient and more cost-saving. Also, our annotated model procedural order for remote video arbitration proceedings. You may remember that as soon as the pandemic hit, we were hard at work on that and released it in April of 2020. We've learned a lot since then, so we have updated it to reflect those learnings. And finally, just a few months ago, our protocol on cybersecurity in international arbitration was also updated. These protocols and guidelines that I just mentioned are really useful tools that can be used regardless of whether it's an ad hoc process or who's administering the matter, although I do hope it will be CPR. One other thing that we recently updated was our employment-related mass claims protocol. This protocol is, I think, a really good example of how the Institute and the service side work together. On our Employment Disputes Committee, we had a task force that came together to work on this mass claims protocol that brought together parties from all sides of the dispute, brought everyone to the table to make a process that we thought was a good way to reduce costs and try to manage mass arbitrations. Our goal in developing the protocol was to help parties work through these disputes in a fair and efficient manner. The process follows an innovative approach that includes having test cases that are decided at the outset. Then a global mediation framework we try to reach a global mediation framework looking at those test cases and informed by those test cases. And in fact, I'm happy to say that Judge Chen, a district judge in California, which is a tough state for employment, noted in a recent decision that the terms of our mass claims protocol appeared to be fair. So one other thing that I know a lot of you are familiar with at DRS is our panel of neutrals. And so I do want to take a moment to talk about what we're going to be doing there. But as all of you might know, our panel of neutrals is made up of over 600 of the most highly qualified mediators and arbitrators from across the country and around the world. We have 30 specialty panels. I tried to go A to Z, but we don't have a panel that starts with the letter Z, so I got appeals to trademark. Close enough. One of the exciting things with the mediation launch, with our new platform launch, is that we are moving our panel of neutrals to be open to the public so that anyone can review our roster, look for neutrals who have our stamp of approval, and see the wealth of experience that we have there. As we make this move, we're also going to be focusing on things we can do to help showcase our neutrals and their expertise, but also take this opportunity to create more of a community for our neutrals through special programming, roundtables, opportunities for networking, and more. And with my last 2 minutes, I want to bring up one last item. One of our new focuses recently has been skills training and education. Last year, we started offering a training program called Innovations in Dispute Prevention and Resolution Tools from CPR, which discusses the latest developments in dispute prevention and resolution, best practices, latest offerings, and goes into our rules and protocols as well. I know some of you in this room have already taken advantage of that. I encourage all of you, if you're interested, to reach out, invite us over to your offices, be it virtually or in person, and take advantage of the offering. And it can carry CLE credit. And in the spring, we held a 5-session training series, and when I say in the spring, I mean a year ago, called the Arbitration Advocacy Skills Training Program. It studied the arbitration process from start to finish, with each session covering a different stage of the process and examining how this era of video conferencing and hybrid proceedings created new obstacles and opportunities. And we had members of our young ADR program steering committee help create this program. It's now available as a resource, as videos on our website. So following the success of last year's series and in line with our continued dedication to education, we're going to be working on creating additional skills training programs throughout the upcoming year. I encourage you to keep an eye on your inboxes for ethical issues in online proceedings, a mediation advocacy skills training where we will focus on skills necessary to be effective advocates in mediation, and soft skills survival guide training for diverse candidates. So it is my hope that all of you will continue to engage with us at CPR's Dispute Resolution Services, whether it's using our rules, our protocols, our neutrals, or our trainings. I do want to reiterate that we are here as a resource for all of you. Please do not hesitate to get in touch and reach out with questions, with feedback, or with ideas for us. Thank you.